It is emphatically the province and duty of the judicial department to say what the law is. Marbury versus Madison, 1803. A decision that was written and reached by John Marshall, Federalist Supreme Court Justice. The background of this case. First, it's important to understand the law, the Judiciary Act of 1789, and more importantly, the particular clause, writ of mandamus. Because Article 3 of the Constitution is so vague, and it doesn't really organize or structure the judicial branch, Congress, 2 years after the creation of the Constitution, wrote a law that would give original jurisdiction or a power to the Supreme Court, and they also put in there what the Supreme Court could and could not do. One of those things that the Supreme Court could do was writ of mandamus, which requires a court or a judge to order a government official to carry out a particular function, like handing a judgeship to somebody who's been appointed as a federal magistrate. The people in this particular case, Adams is president at the time of the Judiciary Act, not at the time of the Judiciary Act, but the time that this writ of mandamus is being enforced. Marbury is the person, a Federalist, who received a judgeship from Federalist President Adams and his Federalist Congress. So Adams appointed Marbury. So this is Adams. He appointed Marbury, and the Federalists in Congress approved Marbury's appointment. Okay. Thomas Jefferson, James Madison, who is Thomas Jefferson's Secretary of State, they're both Democratic Republicans. So that leads us to the importance of the election of 1800. The Federalist versus the Democratic Republicans. Adams versus Jefferson. This election was important because this is the first time where political parties come into play. It's the first election where people are voting along party lines based on what the Federalist government or the Federalist political party was all about, and based on what the Democratic Republicans are also about. The Federalists wanted a strong national government. The Democratic Republicans are like the anti-feds. So they wanted a strong state government. Okay. Well, in the end, Thomas Jefferson and the anti-feds won control of both the executive branch and the legislative branch. So the only hope that the Federalists had in making sure that they still controlled one branch of government was to try to pack the judicial branch with as many Federalist thinking judges as possible. So you have the Midnight Appointments Act, where right before Adams leaves office, he tries to get as many Federalist judgeships appointed and approved by his Federalist Congress as possible. However, he was unable to hand out all of those judgeships before he had to leave the office. Therefore, he left a couple of judgeships behind for Thomas Jefferson and his Secretary of State to carry out and deliver. One of the guys that was supposed to get this judgeship was William Marbury. Okay, so William Marbury was waiting to get his official commission to sit on the federal court as a magistrate. When he didn't get it, he sues. He sues Thomas Jefferson, but he sues particularly James Madison under the writ of mandamus clause. He wanted to force Madison to give him his judgeship. Okay. Now, the case goes to the Supreme Court, and this becomes a political conundrum for Federalist Judge John Marshall. Okay. In this case, John Marshall, the Federalist who believed in a strong federal government and a strong judiciary, faced Thomas Jefferson and the Democratic Republicans, who believed in limited federal government and that the executive should decide if his actions were constitutional or not. So you have basically strong national government versus weaker national government. Strong judiciary versus a little bit stronger of an executive. So Marshall, his conundrum was, if he ordered Madison and Jefferson to issue the commission to Marbury, how could Marshall and the Supreme Court really force an executive to follow the decision? He would look like a chump if Jefferson decided not to carry out that commission. It would actually undermine Marshall's idea of a strong judiciary and a strong federal government if he told Jefferson, you have to deliver this commission to Marbury, and Jefferson just blew him off. Because that's probably what would have happened, because there's nothing forcing Jefferson to truly get that commission to Marbury. So instead of looking like a chump and looking like he was weak, Marshall shrewdly crafted an opinion that didn't require Jefferson to do anything. He didn't require Jefferson to issue the commission, yet Jefferson was told that the Supreme Court decides what the Constitution says, not the executive or the legislature, that this power belongs exclusively to the judiciary because that's its only power to interpret the Constitution. And the way that Marshall wanted to interpret the Constitution is saying that the Judiciary Act of 1789 and the Writ of Mandamus Clause are void because Congress can't tell the judicial branch what to do through a passage of a law. Hence, Marbury, by declaring the Judiciary Act of 1789, basically established the concept of judicial review. So here you go, you can pretend like this little guy in the cartoon is Marshall. I wish for the power to declare I wish for the power to declare laws unconstitutional. The genie saying, why waste a wish on something that you can grant yourself? And that's exactly what Marshall did. He gave the judicial branch the power to declare laws unconstitutional. Let me see if I need to add anything else. Okay, so in the end, the writ of mandamus is denied, declared unconstitutional and unenforceable. Jefferson doesn't have to give a commission. Marbury doesn't receive his commission. And Marshall is able to avoid making the judicial branch look weak by knowing that he wasn't going to get Jefferson to issue that commission anyway. And at the same time, he expanded the power of the judicial branch by establishing the power of judicial review. The effects. The effects are actually exactly the opposite of what the Federalist Papers say about the judicial branch. The Federalist Papers describe the judicial branch as the least bothersome of the branches, with neither the power of the purse nor the power of the sword, and they depend upon the executive for the execution of its judgments. But with the decision of Marbury versus Madison and the establishment of the concept of judicial review, now the judicial branch can review the actions of the president and the laws passed by Congress and declare either one of them or both of them void. And they have done so. So when you write a law and it's not liked, whether you are a state, whether you are Congress, or if you have an executive action, all of that can be reviewed by the Supreme Court and completely overturned or reversed, making that law or action null and void and unenforceable. For example, modern day, the state of California, or no, even better yet, I apologize, the federal government passed a law dealing with same-sex marriages back during the Clinton administration called the Defensive Marriage Act. Defensive Marriage Act said that the federal government doesn't have to recognize the civil unions or marriages of same-sex couples, which means same-sex couples wouldn't be afforded the benefits and rights of heterosexual couples. The Supreme Court in U.S. versus Windsor in this past year, the 2012-2013 term, had an opportunity to review the constitutionality of that law. Now, their decision was that in U.S. versus Windsor, the government, through passing that law, had denied same-sex couples the 14th Amendment equal protection that is afforded to everybody else. Now, agree with that decision or not, it still shows you that Congress wrote a law, even though it took about 20 years, the judicial branch can overturn it. All right. If you have any questions, please come up with some specific things to ask me, and I'll be happy to explain the concept of judicial review over and over and over again, because you know the Supreme Court is my favorite branch. All righty. Bye.